You won your eviction case. The judge gave you a money judgment for unpaid rent, maybe thousands of dollars, and then nothing showed up in your mailbox. One of the most common things I hear from landlords is this: I got my judgment, now the court will collect it for me. I have to be honest with you. That is not how it works. A judgment is only the court's recognition that money is owed to you. Actually collecting that money is a separate legal process with its own steps. Here's the part nobody tells landlords. Winning the judgment and collecting the judgment are two completely different fights. In Massachusetts, the second fight is the hard one, but there is a real legal process for it, and there are moves that genuinely work. I'm going to walk you through the entire process step by step honestly, including when it's worth your money and when it isn't. I'm attorney Joseph Botelho with the Botelho Law Group in Fall River, Massachusetts. We represent landlords and property owners across the South Coast, Fall River, Taunton, New Bedford, and throughout the Commonwealth. This video is about one specific thing: collecting money judgment from a tenant who was evicted, still owes you rent and damages. If you're a landlord who's been through housing court or district court and come out owed money, this is for you. Here's everything we're going to cover: the differences between winning and collecting, how the steps change between housing court and district court, the execution, supplementary process, wage garnishment for tenants who actually have paychecks, how judgment interest quietly grows what you're owed, what happens if the tenant files bankruptcy, why some tenants are nearly impossible to collect from, the constables and sheriff, and the costs you pay directly, how we bill, and something most landlords never think about: the powerful deterrent effect that going after judgment has on your other tenants. Quickly, but important, this is general information about Massachusetts law, not legal advice for your specific case. And watching it doesn't make us your lawyers. Every case is different. When you're ready for advice on your situation, that's a conversation for us to have. Let's get into it. Let's start with the single most important word in judgment collection: the execution. Your judgment is the court's decision that the tenant owes you money. But the judgment by itself doesn't let you collect anything. The document that actually gives you power is called the execution. Sometimes people call it a writ of execution. It's the court's command to a sheriff or constable to go collect that money from the debtor's property. The court does not just mail this to you automatically. Someone has to request it from the clerk after the appeal window has passed. And in Massachusetts, that window is 10 days from when the judgment enters. We calendar that date, request the execution the moment it's available, and make sure the dollar figure on it is right: the rent, the damages, the costs, and the interest that's been running on the judgment. So why does the execution matter so much? The money side of a Massachusetts execution is good for 20 years. That long shelf life is one of your biggest advantages. A debtor who is broke today may not be broke in 5 years, and the execution is still alive and collectible, and the interest keeps accruing on the judgment the entire time it's unpaid, which, as you'll see in a minute, can add up to some real money. Now the process depends on the court, so let me separate them. If you're in housing court, your eviction, what the law calls summary process, and your money claim were usually handled together. The court can issue an execution for possession to physically recover the unit, and a separate execution for the judgment money you're owed. Two different jobs: one gets your property back and the other one goes after the debt. This video is about the money one. If you were in district court, it works much the same way on the money side. You request this execution on the judgment for damages, and then you enforce it. There's a third path some smaller landlords use: small claims for amounts under the statutory limit. Small claims has its own more informal collection track. The clerk magistrate can issue a payment order directly and set a payment review hearing. And if the debtor ignores it, the magistrate can issue a civil arrest warrant. Same destination as the bigger courts, just a different road to get there. Whichever court you're in, once you're holding a money execution, the enforcement tools are basically the same. So let's talk about how we actually use them. And this next part is the section that changes how landlords think about old judgments. So stay with me. In Massachusetts, a money judgment doesn't just sit there frozen. It earns interest, and the statutory rate is high. For a judgment on unpaid rent, which is a contract debt, Massachusetts law adds interest at 12% per year. That's set by statute, Chapter 231 and Chapter 235 of our general laws. And it is one of the highest judgment interest rates in the entire country. And importantly, it's simple interest calculated on your original judgment amount. It runs from the day judgment enters until the day you've paid in full. Let me show you what that actually does. Say the tenant owes you $5,000 judgment. 12% of $5,000 is $600 a year. Watch what happens. After 1 year, $600 in interest has been added, and the tenant now owes $5,600. By year 5, that's $600 a year for 5 years. $3,000 in total interest, and the tenant now owes $8,000. By year 10, $6,000 in accumulated interest, and the tenant now owes $11,000. Those figures are rounded for illustration. Simple interest at 12% of the original $5,000 each year, or $600 a year, and this is not legal or accounting advice. But look at that. After 1 year, your $5,000 is worth $5,600. After 5 years, $8,000. After 10 years, that judgment is worth $11,000. More than double what you started with. The debt didn't shrink while you waited. It grew. So when a landlord tells me it's been 3 years, it's probably not worth chasing, I tell them the opposite may be true. The execution is good for 20 years. Interest has been building your leverage the entire time, and the amount the tenant owes to clear it has only gone up. Time in Massachusetts is often on the creditor's side. Now, one honest caveat, just to keep this accurate over time. The 12% rate is current Massachusetts law. There is a bill, a Debt Collection Fairness Act, that would lower the rate to 3% for certain consumer debts. As of this recording, it hasn't passed the state Senate, but it has passed the state Senate, but has not become law. And a landlord's own judgment for unpaid rent is generally treated as contract debt. We keep an eye on this for you, and we'll tell you the rate that applies to your specific judgment. Let's talk about the tenant with a real job and the tool we use there, which is wage garnishment. This is where pursuing a judgment gets genuinely worthwhile. The former tenant who has a steady, regular job, a normal paycheck from a normal employer, that is the best case debtor. And here's why. Through the court, we can attach that paycheck. The legal term is wage garnishment. And in Massachusetts, it runs through what's called the trustee process. Under Chapter 246 of our general laws, in plain English, we get a court order that requires the tenant's employer to take money out of each paycheck before it ever reaches the tenant and sends it towards your judgment. Let me walk you through how we actually get that done. First, you need the judgment and the execution, the tools we already talked about. Next, we have to find the employer. Where the tenant works is the single most valuable piece of information in the whole process. Often, we pin it down through supplementary process, where the tenant answers under oath about their income. Third, wage garnishment in Massachusetts requires the court's approval. We can't just serve it on an employer on your own, and the law requires that the tenant be given proper written notice first. sent by registered mail before their wages can be attached. And fourth, once the court approves it and the notice period runs, the order goes to the employer, who becomes legally responsible for withholding and forwarding the money. Now, Massachusetts protects a chunk of every paycheck, and you cannot take all of it. The state cap is the lesser of 15% of the tenant's gross wages, or the amount of their weekly take home exceeds 50 times the minimum wage. So there's a protection floor. But above the floor, the money flows to you, paycheck after paycheck, automatically until the judgment plus all the 12% interest is paid off. So why is the employed debtor one to pursue? A wage garnishment is the closest thing to self-driving collection. Once it is in place, the employer does the work every pay period, and it pairs perfectly with the interest math. A garnishment that runs for a year or two collects the original debt and the accrued interest. There's a related tool worth mentioning here too. If you know where the tenant banks, we can use trustee process to reach the bank account as well. Though Massachusetts exempts the first $2,500 in the account and protects things like directly deposited Social Security. Now, let me talk about how we bill, because we do the work hourly, not on contingency. Let me be very direct about money, because it matters to your decision. We handle judgment collection matters on an hourly fee basis. We do not take these on a contingency fee basis. Here's the difference plainly. With a contingency fee, the lawyer takes a percentage of what's recovered and gets paid only if money comes in. That's common in personal injury, where there's usually an insurance policy at the end. With an hourly fee, you pay for the attorney's time in work as it's done, whether or not the money is ultimately collected from the debtor. Why hourly for this work? Because the honest reality we're about to get into, in a lot of these cases, the tenant simply doesn't have the money the law lets us reach. No responsible attorney can promise a percentage of a recovery that may never exist. Contingency only makes sense when there's a reliable pot of money at the end. Judgment collection against an evicted tenant often isn't that. What hourly does is keep everyone honest and aligned. Before we run up your bill, we tell you what we think the odds are. If chasing a particular debtor is going to cost you more in legal time than you could realistically collect, we will tell you that plainly, so you can decide. You're paying us for judgment and strategy, not just motion. And there are costs beyond our time. Filing fees, service fees, the constable and the sheriff, those are paid directly by you, the client. I'll be specific about these shortly. Now, for the honest part, why some judgments are hard to collect. This is the section most lawyers skip in the marketing video. We're not going to, because it's the single biggest factor in whether you'll see your money. Massachusetts law protects a large amount of persons' income and assets from creditors. The phrase you'll hear is judgment proof. It means a debtor who has a judgment against them, but nothing the law actually lets you take. First, protected income. Certain kinds of income are almost completely off limits to ordinary creditors like a landlord. That includes Social Security insurance, SSI, disability benefits, veterans benefits, unemployment, public assistance, and state pensions. If your former tenant only income is government assistance, that income is shielded. You can hold a valid judgment and still not be able to touch a dollar of it. Second, for a regular paycheck, Massachusetts protects far more than the federal floor. That's the protection proof of wages we just discussed. On top of that, a debtor who shows up to a hearing with documentation can protect additional money for rent, utilities, groceries, and a cushion of cash or savings. Put those together, and here's the uncomfortable math. For a lot of low-income tenants, after everything the law protects, there is little or nothing left for a landlord to garnish. That's not pessimism. That's the statute doing exactly what it was designed to do. This is the honest reason we sort your case up for you. The employed tenant with a paycheck is worth pursuing. The tenant whose only income is protected benefits usually is not, at least not today. So, is it ever worth pursuing the judgment-proof debtor? Sometimes yes. Remember, the execution lives for 20 years and keep earning that 12% interest. People's finances change. A debtor who's judgment proof today may be getting a good job in the future, inherit money, or buy property later. You can also record the execution as a lien against real estate. If the former tenant ever buys or sells a home, they may have to pay you off with all that accrued interest to clear title. And some tenants simply to protect their credit or end the hassle of being pulled back into court. This is exactly the judgment call we make with you up front. Pursue now, park it, and revisit or record a lien and wait. So what happens when the tenant doesn't show up at all? That's where supplementary process comes in. This is the tool for a tenant who ignores everything. No payment, no response, no showing up. In Massachusetts, that tool is supplementary process under Chapter 224 of our general laws. Supplementary process is a new separate court action that drags the debtor back into court and puts them under oath about their finances. Here's how it runs. First, we file a supplementary process action, and the court issues a summons ordering the debtor to appear and be examined about their income, assets, and ability to pay. Second, at the hearing, the debtor is questioned under oath and typically completes a financial affidavit. This is where we found out what's really there: the job, the employer, the bank account, any non-protected income. It's also how we get the information we need to set up a wage garnishment. Third, if the court finds they can pay, it can enter a payment order, a court-ordered installment schedule. If it finds they genuinely can't, it may enter findings of no present ability to pay, which pauses things, but does not erase your judgment or stop the interest. Now the defendant who doesn't come to the hearing, this is where supplementary process has teeth. If the debtor was properly served and fails to appear, the court can issue a capias. A capias is a civil arrest warrant. It authorizes a sheriff to physically pick up the debtor and bring them before the judge to be examined. And if the debtor appears, gets a payment order, and then just ignores that order, that can be treated as a contempt of court, which again can lead to a capias. The point isn't to put anyone in jail. The point is that ignoring the court stops being a free option. For a debtor who's been dodging you for months, that shift in leverage is often what finally produces a phone call and a payment plan. There's one practical requirement you need to know about here. Many courts won't issue a capias unless the debtor got in-hand service of the summons, physically handed to them, not just mailed. That's a big reason proper service by a constable or sheriff matters so much, which is our next topic. Before that, let's cover what happens if the tenant files bankruptcy. This is a curveball that catches landlords off guard. You need to understand what it does because it changes the game immediately, and doing the wrong thing can actually get you in trouble. The moment a tenant files bankruptcy, something called the automatic stay snaps into place. That's federal law, Section 362 of the Bankruptcy Code. The automatic stay is a hard stop. It legally freezes almost all collection activity against that person. No calls, no letters, no garnishment, no supplementary process, nothing until the bankruptcy court says otherwise. And I want to be clear, violating the automatic stay is serious. A creditor who keeps pushing after the bankruptcy filing can be sanctioned by the court. So the first thing we do the instant we learn of a filing is to stop and reassess. What happens to your judgment depends on the chapter. Chapter 7 is the fresh start liquidation. Unpaid rent is genuinely an unsecured debt, and unsecured debts are typically discharged, meaning wiped out. If that happens, your judgment for the back rent may be gone. That's the hard truth about Chapter 7. Now, Chapter 13 is the repayment plan. Here, the tenant proposes to pay creditors over 3 to 5 years. Your claim becomes part of that plan, and you may receive payments through the bankruptcy trustee. Often, not the full amount, but sometimes something over time. Two things soften this. First, we don't just sit still. As a creditor, we file a proof of claim so you're in line for whatever distribution there is. And where appropriate, we can ask the court for relief from the automatic stay. Second, not everything is automatically dischargeable. If there's an argument that the debt involved fraud or willful damage, that's a conversation to have with bankruptcy counsel. The key takeaway, the instant you hear the word bankruptcy, stop collection and call your attorney. Bankruptcy is a specialized area, and the automatic stay is not something to test. Now, let's talk about keepers, constables, and sheriff, and who pays for it all. A couple more tools than the costs. If your former tenant runs a cash business, there's an option people refer to as a keeper. With the execution in hand, we can instruct the sheriff to place a keeper at the debtor's place of business, an officer who stays on site during business hours and collects cash and receipts as they come in, applying that money towards your judgment. It only fits a specific situation, a debtor with an operating, cash-generating business, but where it fits, it's effective. We'll tell you honestly whether your debtor is a candidate. Now, the constable and sheriffs, because they run through this entire process. In Massachusetts, a landlord cannot self-serve court papers and cannot personally seize anyone's property. Only a constable or a sheriff can legally serve the summons, serve the supplementary process, papers in hand, levy on the execution, place a keeper, or carry out an arrest on a capias. They are the muscle the law requires. We direct them and tell them exactly what to do, but they are the ones authorized to act. So, which costs do you pay directly as the client? There are court filing fees for the execution and for the supplementary process action. There are constable and sheriff fees for the service of process, in-hand service, levies, keeper service, and executing a capias. And keep in mind, sheriffs are generally entitled to their fee for the attempt, whether or not it succeeds. And there are recording fees if we record the execution as a lien against real estate. These third-party costs are separate from our firm's legal fees and are paid directly by you. We always give you an estimate before we run up the cost, so nothing is a surprise. Now, here's the part landlords never think about: the deterrent effect. This has nothing to do with the law books and everything to do with running a profitable rental business. Word travels. Think about the reputation you have among your tenants. If the understanding on the street is that this landlord evicts you and then just walks away and eats the loss, you've completely told every future tenant that skipping the last few months of rent is basically free. The eviction is the only consequence. And by the time it happens, they were leaving anyway. Now flip it. Imagine the understanding is This landlord doesn't just evict you. This landlord hires an attorney and comes after the judgment afterwards, pursues the paycheck, files supplementary process, records a lien that follows you for 20 years and grows at 12%. That is a completely different message. It tells every current and future tenant that the rent is a real obligation with real teeth behind it. I've seen this change tenants' behavior. Tenants who know their landlord actually collects are far more likely to work out a payment plan, catch up, or leave clean rather than run up a balance they think will vanish. Pursuing judgment isn't only about recovering the dollars in one case, although that matters. It's about protecting every future month of rent across your entire portfolio. The landlords who collect get taken seriously. The ones who don't get tested. Here's the deterrent in one line. Collecting a judgment is partly a recovery decision and partly a business reputation decision. A landlord known to collect rarely has to. So let me tell you what Botelho Law Group actually does for you on one of these matters. We review your judgment and give you an honest, upfront read on collectability before you spend real money. We request and calculate the execution correctly, including all 12% interest that's been building. We locate assets, employers, and income and figure out what's actually reachable versus what's protected. We pursue wage garnishment through trustee process against the employed debtor, the highest value target. We run supplementary process, the filing, the hearing, the repayment order, and the capias if the debtor won't cooperate. We direct constables and sheriff on service, levies, a keeper, and enforcement. We respond correctly if the tenant files bankruptcy, stopping collection, filing a proof of claim, and seeking relief from the stay where appropriate. Where it makes sense, we record our execution as a lien and keep that 20-year interest earning clock working for you. And throughout, we bill hourly and talk to you like a partner in a business decision, because that's what collecting a judgment is. If you're a Massachusetts landlord holding a judgment against a former tenant and you're not sure whether it's worth pursuing, that's exactly the conversation we have every week. We'll look at your case, tell you honestly what your odds are, and lay out your options and costs. Call the Botelho Law Group or reach us through the website. Everything's in the description below. If this helps, subscribe, because we make these for Massachusetts landlords and property owners regularly. Winning the judgment was step one. Let's talk about actually collecting it.